Just weeks until the Supreme Court holds 3 days of arguments regarding the constitutionality of the president's health care law, the government has just filed a brief arguing that even if the court strikes down that individual mandate, the rest of the law can stand on its own. Meanwhile, the court has turned down a request from a group trying to get Justice Elena Kagan to recuse herself from taking part in the case. Joining us to debate the very latest in the health care case, Terry Jeffrey, editor-in-chief of CNSnews.com, and Elizabeth Wydra, chief counsel for the Constitutional Accountability Center. Welcome to you both.
Thank you, Shannon.
Great to see you today.
Good to be here.
Terry, I want to start with you because these latest calls about Justice Kagan come from some documents that your organization uncovered. What are they?
Right. Well, there's really two questions here. One is whether her activities as Solicitor General ought to trigger her recusal from the Obamacare cases. The other question, though, that comes out of this Golden Gate case in particular that I've been looking at is whether her answers to the Senate Judiciary Committee were accurate. And personally, I think if you look at 28 U.S. Code 455, which is a federal statute which governs when Supreme Court justices must recuse, I think the case for her recusal is already made. She assigned the lawyer, Neil Katyal, her top deputy, who was going to handle the case. She didn't assign him to the case to lose it. We know that she sent her good friend Larry Tribe, who was then actually working at the Justice Department, of course, the famed Supreme Court litigator, the day the bill passed. I think we have the votes, Larry, or here we have the votes. Simply amazing. She clearly was a partisan on it. But this other case, the Golden Gate case, goes to the question of whether the answers that she provided to the Republicans on the Senate Judiciary Committee during her confirmation process, particularly one question, where she was asked, after they asked her, have you ever been asked about the merits of Florida's lawsuit against Obamacare, they then asked her, have you been asked your opinion about any other legal questions that may arise from Public Law 111-148? And she said flat no. And I think this Golden Gate case raises questions about that.
Well, and just to give people some background, this is a case that came out of San Francisco dealing with the local health ordinance there. The Solicitor General, when Justice Kagan was Solicitor General, her office filed a brief here, and it did discuss the president's health care law. It's noted by an internal memo that she was substantially involved with that case. But Elizabeth, you say the cases are so different, there isn't a conflict.
Absolutely. The Golden Gate case has nothing to do with the constitutionality of the Affordable Care Act. It simply notes its existence as a then recently passed law that alters the federal landscape in terms of the issue that was actually involved in the Golden Gate case, which was whether a 1974 federal law, RISA, preempted San Francisco's local ordinance. The allegations are just simply, to be frank, silly. And I think the way that, it's very telling the way they've been argued to the court in a brief that's full of insults against the justices and rants against conservative Chief Justice John Roberts. And that's just not the way that you make serious arguments in the Supreme Court.
Well, and the Chief Justice himself has noted that there are outside groups calling not only for the recusal of Justice Kagan, but Justice Thomas as well for different reasons. And he said he trusts his colleagues to make their own independent decisions. Terry, is that not good enough for you?
Well, I think Kagan is going to make the decision. On the recusal, by the way, that law, 28 U.S. Code 455, if you look at the questionnaire that she submitted to the Judiciary Committee during her confirmation process, she said that she would be governed by the letter and spirit of that law. The first prong of it says that if your impartiality can be reasonably questioned, you ought to recuse. It also says if in prior government employment you had either served as an advisor or counsel in a particular case in controversy or expressed an opinion about the merits of it, you need to recuse. I think clearly, given that she was a partisan of Obamacare, clearly, given that she named the actual attorney, Neil Katyal, a brilliant attorney, by the way, who argued this case in multiple appeals courts, she had an interest in this as Solicitor General. But again, as I say, this Golden Gate case goes to a different question, including the question of recusal. There's also the question of whether she seriously did not ever, as Solicitor General, discuss other legal issues arising from the health care law. And in this brief, by the way, folks can go online and read it, the actual argument that her office made in this brief that she substantially participated in the preparation of was the Supreme Court ought not to take up the challenge under ERISA to this San Francisco universal health care law because PPACA, the Patient Protection Affordability, totally changed the landscape regarding this case. So it said it's all about PPACA.
All right, but Elizabeth, ultimately the decision is hers.
Absolutely, and in both the case of Justice Thomas and Justice Kagan, the Chief Justice, Justice John Roberts, backed them up in his year-end report and said, I trust my colleagues to make the right decision, and to the extent there have been any legitimate questions of recusal, they have been asked and answered at this point, and it's time to move on to the merits of the case. And I think any further attempts to bring up these grasping at straws types of arguments about recusal simply hurts the credibility of opponents of the Affordable Care Act.
We got to leave it there. I thank you both for the debate. We would love to have you back because we'll be talking about this case quite a bit as we are just weeks away now. Terry and